Judge President John Hlophe has been postponed indefinitely. Now, this is to accommodate a review application to be lodged by the two key Constitutional Court witnesses. That's Judges Chris Jafta and Bessin Kabinde. Hlophe is accused of trying to influence the judges to deal favorably with a corruption case involving President Jacob Zuma back in 2008. The judges laid a complaint against Hlophe's conduct at the time. They've now asked to be excused from the tribunal pending the outcome of their review application to the High Court. Courtney Griffiths QC and attorney Barnabas Xulu are the two lawyers defending Judge Hlophe, and we have them both in studio with us. Gentlemen, thank you for being with us. It's an absolute pleasure to have you.
Our pleasure.
Thank you.
The two judges, Jafta and Kabinde, insist the tribunal is not the right vehicle to deal with a misconduct hearing. Do you agree with them? Barnabas, would you like to begin?
Yes. We have made our indication about the objections that we've been having with the tribunal as it was set up, in a sense that there was no compliance with a very important requirement of Section 14.3 of the Judicial Service Commission, which requires that the complainant are expected to depose on an affidavit or an affirmed statement to trigger the process or to trigger the proceedings. In this case, we did not have that, and as such, we have made that as one of the preliminary substantial point, basically saying these proceedings are not going to be able to proceed fairly, in a sense that there is no signal of willingness or voluntariness from those who are regarded as complainant.
Okay.
But that objection which we have raised has been dismissed by the judge sitting as the president of the tribunal.
Yeah. All right. Now, we've seen that the evidence leader, Kolesiwe Kanyisile, agreed to the postponement, saying she was unable to continue without the two key witnesses. Do you agree with this decision?
Well, no, I don't actually.
You don't?
For this simple reason. The evidence leader's job is to present the case against Judge President Hlophe. She has known for some time, because as long ago as June 2008, the two judges indicated that they had no intention of being individual complainants against the Judge President. So that's been known for many, many years. So to that extent, the two judges have been consistent. They've stood by their principled position since June 2008. The evidence leader knew this, and yet we've continued in this vacuum, in a sense, for the last 5 years, everybody knowing that they were not inclined to give evidence against the Judge President.
Yeah.
We find that quite unsatisfactory, frankly.
Hlophe has been accused of delaying this whole process.
Well, we totally refute that suggestion, because as we know, years ago, way back in 2009, the Judicial Services Committee found that there was no case to answer. And an organization called FULL, Freedom on the Law, and also the Premier of the Western Cape, decided to challenge that decision in the superior courts. And that's the main reason for the delay. And again now, the delay is nothing to do with Judge President Hlophe. It's to do with an application by the evidence leader. And so consequently, we don't accept the blame for any delay which has occurred.
Yeah. Do you ever think there's going to be closure to this?
Well, it depends on the cooperation of the parties involved, mainly those who are pushing for this matter to go ahead when they know very well that there is no complaint that has been laid, or there is no complaint that can hold water against our client. And we've seen it now where an evidence leader agrees that a matter be set down and at the expense of the state, when in fact he has never even had a consultation and a readiness from the side of those that she regards as complainants.
Yeah.
And as a result, we are in this situation.
All right, now we see the latest is that Jafta and Kabinde have lodged a High Court application for a review of last week's tribunal decision to proceed. Is this a wise move?
Well, One has to question the behavior of many of the Constitutional Court judges during this rather shabby saga. Over the weekend, for example, we had a number of judges of the Constitutional Court making anonymous comments, clearly in an effort to put pressure on the two judges to give evidence before the tribunal. Now, we find that inexcusable and unacceptable for this simple reason. These are judges who may be required in due course, as a result of the action currently being taken by those two judges, to rule upon this issue. What business do they have making the kind of comments that they did over the weekend in the press about two of their colleagues on an issue upon which in due course they might be adjudicating? They had no business doing that. And it's the most deplorable behavior by judges of the most senior court in the land.
Yeah.
Particularly when it comes to two of their colleagues.
Yeah. Well, I mean, you know, talking about that, we just hear that Justice Dikgang Moseneke will avail himself to testify at the tribunal as well, and that there was no need to subpoena him. You know, what do you make of this?
Well, I would welcome an opportunity to ask him a few questions. The issue is whether or not his evidence alone, given that he wasn't privy to the conversations which formed the crux and core of this issue, to what extent his evidence can assist the court. But there are other things we'd like to ask him about.
What are those?
Well, we would like to know, by way of example, how it is that two judges of the Constitutional Court on the 12th of June 2008 say, we're not complainants. We have no intention of complaining against Judge President Hlophe. And a couple of days later, curiously, they sign a joint statement saying that they're joint complainants with all the other judges of the Constitutional Court. And here we are 5 years later, them reverting to their initial position. What happened in the interim? What happened? Now, we'd like some answers to that.
Yeah. Do you believe or do you feel that there's political interference in this case?
Well, I'll ask Griffiths to deal with that.
I think obviously there is politics involved here. What the core reason for that is difficult to pinpoint. But it's difficult to explain how it is that we've had this, to borrow a phrase I've picked up since I arrived in South Africa, flip-flopping in position between various judges on the Constitutional Court. And one wonders, what is motivating that? What is causing these judges of the most important court in the country to be changing their position and adopting such diametrically opposed positions towards each other?
Surely when a president of a country is involved, it adds it to a very sensitive situation.
Well, of course it's sensitive. Of course it's sensitive. And in a sense, that may well explain how this whole issue blew up in the first place. Yeah. Because as someone who has sat as a part-time judge in the United Kingdom for almost 15 years, I appreciate that oftentimes judges, when they have important decisions to make, will consult with their colleagues, or indeed their colleagues, unsolicited, might offer opinions on the topic upon which judgment is to be pronounced. And it just surprises me that, given that natural tendency amongst the judiciary, why this particular instance has been blown out of proportion in this way, unless, as you rightly observe, there is an element of politics involved.
All right, just finally, Barnabas, where to from here? What's going to happen?
Well, we are in the hands of the courts system, which basically means that the court will indicate which date it gives the judges for a review application, and we await the outcome. It can be something like 3 years or 4 years, depending on how quickly the court accommodates this matter. But we also have issues that are remaining with the tribunal as it is sitting. It has not been interdicted. There are issues where we want this tribunal to issue some ruling on. For instance, on the comments that has been made by QC here on the judges making comments in public, but they don't disclose themselves, because we know that it is poisoning the situation, in a sense that if the matter ends up in their hands, will they recuse themselves? Because we don't know them. Now we'll have to ask every judge that the matter is before whether to recuse or not.
Yeah.
But as I say, from where we are now, we just have to we will be in the hands of the court in terms of when they finalize this matter either way. If the tribunal is regarded as an illegitimate structure to deal with this matter, then that will be the end of the matter for the tribunal to hear the matter. And the matter will obviously be going back to the JSC. But at the moment, we are in the hands of the courts to decide the matter.
All right. Gentlemen, thank you so much for joining us here on Morning Live.
Our pleasure.
To talk about and unpack this case.
Thank you.
QC Courtney Griffiths and Barnabas Xulu, who is attorney, and are the two lawyers that are defending Judge Hlophe. Right, the time now is